So good morning, everyone, and welcome to this behind the scenes look into how the ICC court works. We are very happy to be here with you today for this special webinar where together we're going to go behind the curtains into the secret workings of the ICC court, and we'll discover together how this mysterious organisation works and how decisions are taken. What's more, we're very lucky that you're all doing this from the comfort of your own home or office space, which is just the same way that the court sessions actually take place. So I hope you've all got a nice cup of tea like I have, and we're ready to dive in. So I'm going to start this session by giving you a brief explanation of how the court works before we move to the main event, the mock court session. There is going to be a chance to ask questions or make comments at the end. So if anything comes to mind, please put it into the chat and we'll deal with it later. There's also going to be a chance for you to vote during the mock court sessions, so you can also play the role of our court members. I would just stress right from the outset that this webinar is taking place as an educational tool. We're very lucky to have real life court members with us today. However, the discussion and comments that they will be making in the mock session should not be taken as their own opinions. So if there's anything you hear that you think is controversial, it just means that they're playing their role really well and are being deliberately dramatic for your entertainment. So what is the court and what does it do? So the ICC court is the independent body of the ICC. It was established in 1923, which means that next year is our centenary. So do look out for lots of events going on around the globe next year, because we're going to have a lot of fun celebrating our 100 years. It is an autonomous body which carries out its functions in complete independence from ICC and its organs. The court itself does not settle the disputes. Its role is to administer the resolution of disputes by arbitral tribunals in accordance with the rules. It is composed of one president, which since the 1st of July 2021 is Claudia Solomon, as well as 17 vice presidents and 175 members from 116 countries and territories around the world. Our court members are not full-time members of the court, except for the president. They are arbitration experts in their own right, who either act as independent arbitration practitioners, work in law firms, or as in-house counsel, and come and do this as additional tasks to help us out and spend an amazing amount of time to make sure that the court runs. They're appointed for 3-year terms, which are renewable once, by the World Council on the proposal of national committees. The court is assisted in its work by the Secretariat. These are the case administrators that you have your day-to-day contact with. We have approximately 80 staff from diverse nationalities and languages. We have 12 teams. Each team is made up of 1 counsel, 2 or 3 deputy counsel, and 2 or 3 assistants. 7 of our teams are based in Paris, and we also have 5 overseas teams in New York, Sao Paulo, Abu Dhabi, Singapore, and Hong Kong. So what are the court sessions? Well, the court is not a court in the traditional sense. It's not a building that you go into and sit for the sessions to take place. When we talk of the court, we're talking about the people. So the court sits in weekly sessions. In these sessions, we have 3 members of the court, either the president or vice president and 2 other members. And in these weekly sessions is where most of the decisions of the court are taken. So, for example, any decisions on jurisdiction pursuant to Article 6.4 of the rules, fixing the place of arbitration, constituting the tribunal by fixing the number of arbitrators and appointing or confirming arbitrators, which we'll see later. Any decisions related to the financial aspect of the case, and at the end, the scrutiny of the award. As I said, these cases take place virtually. And so what you will see in the mock court session is how it actually does take place. We then have special sessions of the court, which take place either once or twice a month. For these sessions, we have 1 president or vice president and at least 6 other members. And these cases, we deal with challenges or awards that contain a dissent in opinion or have a state entity involved. For cases run under the expedited proceedings, the awards are dealt with by single member committees for the rapidity. And we also have a plenary session of the court, which normally takes place at the annual working session, where all members of the court are invited to attend, either in person or online. So how does the court actually take its decisions? Well, for each case where the court needs to take a decision, the Secretariat creates what we call an agenda. The agenda includes the pertinent information the court may need to take its decision. So information on who the parties are, what the contract is, what the arbitration agreement says, and who the signatories are, a summary of the dispute taken from the parties' request and answer, the stage of the proceedings, including the work done and what's still left to be done, as well as the financial information. For each decision which then needs to be taken, the Secretariat will set out what the issue is. It sets out a summary of each party's position taken from their submissions, and if necessary, will then attach those submissions or additional evidence as annexes to the agenda. The main body of the agenda is then the analysis of the Secretariat. Here, the Secretariat analyses and highlights the main issues for the court and informs the court of past precedents which may help guide their decision. And finally, the agenda would contain a recommendation. So in most cases that are straightforward, there would be a recommendation to take an action. For example, the Secretariat recommends that the court confirm X as arbitrator. However, in complex issues, in which we will see during the session, the Secretariat might not take a view and simply leave it to the court to examine whether to take a particular action after setting out the pros and cons of each decision. So let's move to the mock session. Before we jump right in, let me briefly introduce our actors for today. As I say, we're very lucky to have real life court members join us, and even more lucky that each of them are qualified in England and Wales. So we have Ms. Danga Camus, who's Vice President of the Court. She's from Kenya, but based in The Hague. She's an international lawyer focused on international dispute settlement, public international law, and private international law. She regularly acts as arbitrator. Luckily for us, she was the inaugural president of the ICC African Commission and is member of far too many organisations we have time to list. Today, she'll be playing the role of Vice President and Chair of the session. Robert Pay is a UK national based between London and Hong Kong. He represents Myanmar as court member. He is an independent arbitrator and mediator admitted in the UK and Hong Kong, and he acts in a wide range of sectors, list just a few of them: commercial, financial, investment, and shareholder disputes. And he will be playing the role of court member. Louise Riley is an Irish national based in Dublin and represents Ireland as a court member. She's a barrister who specialises in sports law and international arbitration. Louise acts as arbitrator and is regularly appointed by international sports bodies to investigate and adjudicate allegations of wrongdoing, and also sits on far too many panels for us to list all of them today. She will also be playing the role of court member. Then we have Colleen Parker, who is Deputy Counsel in the Common Law team at the Secretariat of the ICC. She's been with us for just over a year. She is American, but a common law background, and has completed legal studies in the US and France, and she'll be playing the role of the team in charge of the file. And finally, I'm Ashley Brocchieri, counsel in charge of the common law team at the Secretariat. However, for the purpose of today's session, I've given myself a small promotion and I'll be playing the role of the management of the Secretariat. Let me just stress once again that the comments you will hear today are for educational purposes only and do not represent the actual views of any of our speakers. Okay, Danga, over to you.
Thank you very much, Ashley. I'll go directly into role. Good morning and welcome to this committee session of the court. You will see that we have a truncated court session with only 3 matters before us today, which all relate to the confirmation or the objection to the confirmation of arbitrators. Normally would have a much longer list of matters to consider, including awards, partial awards, final awards, even consent awards, and other procedural decisions such as advance on costs, advance on fees, and even withdrawal of cases. So starting with the first matter before us, this is an objection to confirmation of an arbitrator, and I'll turn to the Secretariat to give us an overview of what the court should be deciding this morning.
Good morning. So for the first case that we'll be looking at today, the dispute concerns a highly technical semiconductor case seated in London with an arbitration agreement that requires an arbitrator of UK nationality specialized in semiconductor knowledge. Claimant has nominated a co-arbitrator who disclosed that she has previously been nominated by claimant in 3 previous unrelated cases, 2 of which ended in final awards in 2019, and 1 of which settled in 2020 prior to the evidentiary hearing. After the submission of her forms, respondent has learned that claimant's nominee is currently acting as co-arbitrator, also nominated by claimant, in an ongoing case that they learned of through the publication of a news article concerning a partial award recently rendered in this 4th case. The co-arbitrator was asked to clarify this point by respondent, and she quickly confirmed that she was in fact appointed in this 4th case by claimant and apologized for the oversight and indicated that in fact all of these 4 cases were listed on her website and that she was not trying to hide the existence of these cases. Furthermore, these cases are all unrelated, but the subject matter does concern the semiconductor industry, which requires some technical knowledge. And claimant has argued that it is therefore reasonable for her to have been repeatedly appointed in light of her experience in this area. They also argue that this is a publicly available information that respondent should have made itself aware of. Respondent has objected to claimant's co-arbitrator's nomination on the basis of these 4 nominations by claimant in the past 10 years. Respondent has also requested that the court provide reasons for its decision today. The Secretariat is inviting the court to examine whether to confirm the co-arbitrator nominated by claimant in light of the 4 nominations by claimant in the past 10 years.
Thank you very much, Colleen, for that background. It's very useful for the court. And we take note that the Secretariat's recommendation for the court is to examine whether to confirm the arbitrator. And with that, I will turn to my colleagues to get their first reactions on this matter. And taking the principle of ladies first, I will start with you, Louise.
Thank you very much, Nanga. And thank you, Colleen, for that very helpful introduction and outline of the facts. As you point out, Colleen, there are 3 issues here, and perhaps the easiest way of dealing with it would be to go issue by issue. So looking first at the repeat nominations, I have to say that looking at the issue of 5 nominations in 10 years does not immediately concern me. I know we can turn to the extent to which we want to look at the IBA guidelines, but the IBA guidelines tends to look at disclosure of more than 3 nominations in the past 3 years. So 5 and 10 years does not, it's not an immediate red flag for me. But I know we have other issues as well. So I know that sometimes when we discuss these things, the first issue may not be dispositive, but taking the 3 issues together can lead us to a different outcome. So if we want to take it piece by piece, I have to say that, you know, the repeat nominations is not of immediate kind of dispositive concern for me. And I suppose in part, you know, part of our looking at the past nominations, I suppose we should look not just the number, but also what was actually involved, you know, how closely connected were the issues, how closely connected were the individuals. But I'd be very interested to hear Robert's view on that point. As I said, it's not an immediate concern for me, but it's definitely one to be looked at in the context of the 3 issues.
So why don't we do that, Louise, and take them issue by issue, and turn to Robert now to hear your views on the number of nominations, repeat nominations.
So I have to say I'm in strong agreement, violent agreement even with Louise. I don't immediately see 5 nominations in 10 years as being problematic, particularly not when one takes into account the specialist nature of this case. So this is very technical. It's a semiconductor case. There's a limited pool of candidates with the requisite expertise. And I don't myself see a problem with her receiving the 5th nomination in this case. So I would agree with Louise's analysis.
I have a different view. Thank you, Robert. I'm a bit concerned with the 5 nominations, and particularly because not all other instances were related to specialized knowledge. So we may start seeing here a comfort with the arbitrator, which may be of concern to the court. But we do have other issues to consider. So perhaps, I may be persuaded that this is not in fact a problem. So perhaps we could turn to the other two issues and look at the lack of disclosure. Is that something that should be of concern to the court? The fact that the arbitrator did not disclose her involvement in this fourth case. Robert, perhaps we could start with you on this one.
I mean, obviously it's unfortunate that she did not make the disclosure, and she should have done, but it's clearly inadvertent. The fourth case is listed on her website. I think it's reasonable to assume that a counsel doing their work thoroughly would look at the website of any arbitrator who's involved with the case. So I think it's true that, as she has suggested herself, this wasn't deliberate. And as we know, non-disclosure, while it is an important matter, in and of itself, it should not elevate our concerns to a point where we have to say, no, we will not confirm the candidate just because of the non-disclosure. So speaking for myself, I think the non-disclosure is unfortunate and it's unhelpful, but I don't see it as decisive in any way.
Thank you, Robert. I think it might help us to hear from the Secretariat on what the court has done in previous instances. But before we do that, Louise, do you have anything you'd like to add at this point? Or
I'm inclined to agree with Robert. And I think for me, when the issues of non-disclosure come up, I think the question I usually ask myself is, was this deliberate? Was the nominee trying to conceal something? And I don't think that's the case here in circumstances where the appointment was publicly available. And I think there is a certain duty on counsel as well, when they see the name of a nominee, to do a little bit of due diligence. I'm not talking about any kind of deep investigative work, but a simple search of this nominee's publicly available online CV would have disclosed the relevant information. So similar to Robert, the non-disclosure issue, in circumstances where there's no indicator it was deliberate or she was deliberately trying to conceal anything, that doesn't overly concern me.
Thank you very much, Louise. Could the Secretariat perhaps guide the court on how we have decided in previous instances, if there are any precedents that would be of use in our decision?
Of course. So in terms of the non-disclosure, the discussion you had actually captures the court's previous workings. So disclosure is not in itself a ground for disqualification. However, it would be considered by the court in assessing whether to confirm an arbitrator or not. The court has at times in the past not confirmed nominees or accepted a challenge later on the basis of non-disclosure or of a partial disclosure in circumstances that were of sufficient nature which may call into question the arbitrator's impartiality or independence. The sort of factors that the court would consider was whether the situation would fall under the normal disclosure obligation, whether respondent was aware or could have been aware of the situation. So for example, here where the situation was not detailed on the form, but was available on the CV. And how serious the disclosure would be in as itself. Like I say, not decisive, but should be a factor that's considered within all the facts.
Thank you very much, Ashley. That's quite helpful. Perhaps, and something we may want to consider just for the fullness of the discussion is, would it make a difference to you, Robert and Louise, if the nominations of the arbitrator had come from the council rather than from the party itself? In this case, we have the party doing the nomination. So the 5 nominations have come from the claimant themselves. Would it make a difference to you if those had come from the council? I'm trying to see if I can be persuaded to join you in not being concerned about the repeat nominations.
I'm just thinking this might be an area where it would also be helpful to have some guidance from the Secretariat as to the approach taken previously by the court. Would that be possible?
That's always a good idea. Ashley?
Absolutely. So in terms of repeat nominations by the party themselves, What the court looks at is not just the number of arbitrations in which an arbitrator has previously acted, but also whether these may create a risk of asymmetry of information or otherwise influence the arbitrator's judgment. So a few examples in the context of confirmations. In one case, the court decided to go ahead and confirm an arbitrator who had been nominated 3 times in 5 years by the same group of companies. In this case, all cases were unrelated and ongoing. On the flip side, it decided not to confirm a co-arbitrator who was nominated by the same party in 4 related cases within 2 years. And in that case, the court decided the cases may have involved similar issues, and there may have been a risk of either prejudgment and or asymmetry of information. Turning to cases where the nomination came from the council and not from the parties itself, the court has in the past confirmed an arbitrator who has been nominated by the same council on a number on 3 occasions in 6 years, of which 2 cases were the same 3 years, because there was no link whatsoever behind the nominated parties. However, the court in one case decided not to confirm an arbitrator who had acted as arbitrator 3 times in 3 years by the party, because there was some indication that there may be a trace of cases between the respondent and its counsel starting to, or some sort of pattern starting to emerge, which could raise doubt as to the independence and impartiality. So there is a difference to be made between the party and the council.
That's very helpful, Ashley, and it helps me in my thinking on this. Robert, Louise, do you have anything you want to add on this matter before we turn to the question of given reasons?
Just on that.
Oh, sorry, go ahead.
Sorry, excuse me, Robert. Just on that point, thank you, Ashley. That was extremely helpful. And do you know, or can the Secretariat give us more information on how closely related the previous cases were? Because there, I think there may be an issue. If it's a case that the arbitrator may have additional information, or as you say, the asymmetry in terms of information. So if we have one member of the tribunal with more information than the other 2, that could skew things like slightly, and that's where I would start being concerned. So, and perhaps the Secretary doesn't know, but to the extent you do know how closely related the previous cases were substantively, I think that'll be a useful factor for us to consider.
It doesn't appear that there's really any other relation to these cases. The contracts are different, the parties are different. It's really just the fact that they are within the same industry and do involve semiconductor disputes. And so this technical knowledge is relevant, but otherwise it doesn't appear that there's any sort of crossover between the previous cases and any of the underlying issues or parties in the current dispute.
Okay, thank you, Colleen.
That's helpful. Robert?
So I guess one thing to have in mind is that the case is seated in England and Wales, I believe, and I think that is likely, as I understand it, to be the place of enforcement. So I think it would be reasonable to at least take into account the English law position, and so I think we could at least have in mind Halliburton and Chubb, which I appreciate has caused lots of debate and analysis. But my feeling is that Halliburton and Chubb would favour the view that we can confirm the arbitrator in this case. It made very clear that even in the context of the same subject matter, as long as a fair-minded and informed observer would have no concerns about impartiality, then it's legitimate for us to confirm, or at least it would stand in favour of confirmation, I believe. So I would just, I guess, cite that as further, well, in favour of confirming. Obviously, Danga, I have huge respect for your views, and you may very well be able to persuade us that we're wrong, Louise and I. But I think it's worth just at least having in the balance Halliburton and Chubb as well.
Yeah. Thank you, Robert. We'll recall that the court is, of course, not bound by national courts. But of course, we do have a duty under Article 42 of the ICC rules to make sure that the award is enforceable. So it's very helpful to take into consideration what would be applicable in this at the seat, in this case, which is London. And as we'll recall, the court doesn't have a specific standard that it applies to confirmation, no particular threshold, but it does generally apply an objective test. So I think, having heard the discussion that we've just had and the precedents that the court has in confirmations, perhaps it may be that you have persuaded me that this objection should not stand. But we'll turn it to the audience and see how the audience would decide. But before we do that, perhaps just a note on the request for reasons. So we have here a case where there has been a request for reasons by the respondent and an objection to that request by the claimant. And I would welcome your views, Robert and Louise, on how we should decide this matter before we turn to the audience. Louise?
Thank you, Lenga. My understanding is, unless the objecting party puts forward a very good reason for the court not to provide reasons, the default position is that we should. And perhaps I could look to Colleen again and ask her, are there any specific reasons for the party's objection?
No, we haven't been given any particulars as to that, and it's true that normally the court favors providing reasons in situations that they are requested, and in fact is hard pressed to come up with good reasons for an objection to that request.
Thank you, Colleen.
Robert, anything from you?
So not really. I just agree. I think it's very clear that we do need to provide reasons in this instance. Thank you.
And that is in line with the court's movement towards more transparency. So unless there is really a very clear reason raised by the party objecting to reasons, then it is the court's practice, and should remain so, to give reasons where those are requested. So with that, we'll turn to the audience to see how they would have decided, to see whether they would have confirmed or not this arbitrator.
I'm pleased to see panelists are not allowed to vote. I was just trying to do so, but.
Perhaps while people are voting, there was a question from the audience asking, if this was real, would you identify the arbitrators and the law firms? And in real life, we would. In the case, in the Secretariat's agenda, as I set out in the beginning, there are details of who the parties are, who the counsel are, and who the arbitrators are. We then, of course, have maintained strict policies that anyone who may have any link to the case would be excused from the cases which are being discussed. So they'd only be the neutral people, of course.
We cannot see the results of the vote. We can now. So 91% of the audience says yes, the court should confirm the arbitrator, and 9% say no, which perhaps tracks quite closely how the court would have decided on this one. Thank you very much. So we turn now to the second matter, which is also an objection to confirmation. And I will request the Secretariat to give us a brief background on what the court should decide in this second matter.
So the second dispute concerns a construction issue also seated in London. In this case, respondent had nominated its co-arbitrator. Prior to the confirmation of the co-arbitrator, the case went into abeyance for several months and has only recently come out of abeyance. The Secretariat invited the co-arbitrator to update their statement of acceptance and availability, and they came back to us indicating that there was nothing to disclose, but they have changed law firms in the interim period during abeyance. during this time. Claimant has found out that the large law firm that the co-arbitrator has joined is representing one of respondent's subsidiaries, or has been advising them out of their Hong Kong office. The co-arbitrator, once informed of this fact, ran an additional conflict check and indicated that in fact this was the case, although they were not previously aware that this subsidiary had a connection with their new law firm, because the subsidiary was not listed as a related entity when they ran this check. So it appears to have been an oversight on their part, but it has been confirmed that in fact the Hong Kong office has been advising respondent subsidiary on tax matters. The co-arbitrator denied any impropriety on the basis of this and indicated that it's a different office of the firm advising on different matters, and they therefore see no reason why this should affect their impartiality, and that this client represents a very small amount of the law firm's overall business. The law firm has also offered to ensure that no funds from this subsidiary go towards the co-arbitrator, and to screen them from all activities related to the advising to the respondent subsidiary. Nevertheless, claimant has objected to the confirmation on the basis that this financial link between the co-arbitrator and co-arbitrator's law firm and respondent subsidiary, this financial link creates an impairment to their independence and impartiality. In light of this objection, the Secretariat invites the court not to confirm the co-arbitrator nominated by respondent. But happy to hear your thoughts.
Thank you very much, Colleen. So in this case, in contrast to the first one where the Secretariat's recommendation was for the court to examine whether to confirm, here there's a clear recommendation from the Secretariat not to confirm. And the two issues that the court needs to consider when deciding whether it should confirm or not are the issue on the financial links and the non-disclosure. So with that, I will turn this time, start with Robert, to see his views on how the court should decide on this matter.
So I know that the court takes a very strong and stringent view. If there's any kind of financial link whatsoever, then the arbitrator should not be confirmed. And in fact, from reading the helpful agenda prepared by the Secretariat, I've seen that in a past case, an arbitrator was not confirmed where his law firm was receiving 0.0001% of its annual total revenues from an affiliate of the party that had nominated him or her. So, I mean, this rule is stringent, it's taken seriously, and I can't see why in the circumstances before us now, we would try to bend that rule. As regards the non-disclosure, as we saw earlier, it's not in and of itself necessarily fatal, but it's certainly an exacerbating factor in these circumstances. And as always, the Secretariat's recommendation carries a lot of weight, certainly with me, and I think with all members of the court. So I'm in favour of not confirming this arbitrator.
Thank you, Robert. Louise?
Thank you, Danga. I'm in agreement with Robert. For me, you know, when we discussed the first case, non-disclosure wasn't a huge concern. By contrast, a red flag for me in considering nominations and appointments is financial link. So for me, I think where there is a financial link between a nominee and one of the parties, that really does raise very serious questions in terms of independence and impartiality from you know, objectively. Obviously, I'm not saying that specifically in this case, but I think that there is an objective view that as soon as there's a financial link, I find that hard to overcome unless there are very good reasons to do so. Similar to Robert, I place a lot of weight on the Secretariat's recommendation. We read the agendas in advance of the court meeting, but we don't live and breathe the case the way the Secretariat do. They're much closer to the case than we are. So for reasons which Robert has stated, and also in addition to the reasons set out in the agenda, I agree with the Secretariat's recommendation not to confirm.
Thank you very much, Louise. Well, at the risk of being devil's advocate, in this case, we do have a situation where the law firm has said that it would ensure that this arbitrator does not receive any financial benefit, which might impact on the ability to serve as an arbitrator. And more than that, that they would screen them from all activities that are related to the work of this affiliate. Should this not feature at all in our thinking and in our decision making? I take the point, of course, of the financial links, and that's for good reason. That's what the court's practice is, and it's it's there for very good reasons. But given this offer to do things a little bit differently, should we not be persuaded otherwise? And maybe we can turn to the Secretary to give us any precedential practice that might answer my question. But I just thought that we should deal with this with these questions.
Yes, and it's a useful point because, in fact, the respondent or the claimant should discuss the IBA guidelines and whether this may be on the waivable red list. But from our perspective, we are more guided by our own policies, and in particular that's in the note to parties and arbitrators, which indicates that we treat the identity of law firms the same, and we give that identity to the arbitrators themselves. So we don't make a distinction between a different branch of the office, even if it's on a different continent, even if it's a different group within the law firm that's doing the act of advising or representing the parties. We really treat them as one and the same. And so the law firms offer to sort of create a Chinese wall, if you will, between the activities of the subsidiary and their firm don't factor into our decision with our analysis of whether or not we should consider this financial link between the co-arbitrator and the law firm and the subsidiary.
Thank you very much, Colleen. That's very helpful. I'm going to turn to my colleagues to see if they have any.
So I'll just say thank you, Danga, for raising that. It's important that we do cover it off.
Anything more to add on this? Otherwise, we'll go to the audience and see. Yes.
So I was just, sorry, I think there was a delay. I was just saying thank you for raising that. I think that is an important point, and it's good that we cover it off. But I think, having heard from the Secretariat, it's very clear that the offer to put a wall in place is not going to be sufficient to resolve the problems here. And so my view continues to be that we should not confirm. Thank you.
Yeah, likewise. I mean, I think it's, it indicates an attempt to mitigate the issue by the nominee, which I appreciate, but it's slightly artificial at the same time, saying this person won't personally benefit. Well, the firm benefits, therefore partners of that firm will also benefit. So I think that attempt to kind of screen or hive off an individual is slightly artificial. So similar to Robert, that does not change my view. Thank you.
Thank you, Louise. And of course, the other point to note is that while the court takes note of the IBA guidelines, it has developed its own practice, such as here, where it treats the law firm as a whole rather than chopping it up into its constituent elements. And that's important when considering how the ICC court would respond to issues of an arbitrator's independence or not in its decision making. So with that, we'll have the poll again, and we'll see how the audience would decide. You're seeing from the court an inclination not to confirm, following the Secretariat's recommendation. So let's see what the audience thinks. we have the results. We have 22% who say, the question is, should the court confirm the arbitrator? That's the question in the poll. 22% say yes, and 78% say no. So that again tracks the court's decision, or what the court's decision might have been in this case, but perhaps with a greater percentage saying they would confirm than we might have anticipated, which is interesting, and I think reflects the reality that there are different considerations to make when addressing these sometimes complex factual scenarios involving arbitrators and their links. Now, we have about 16 minutes left in this session. We have one more scenario, but I also see that there are several questions in the Q&A. And I wonder whether, Ashley, it might be better to go to the questions so that we have a discussion. And I see some of them will raise kind of some quite useful elements about how the court works, which I think the audience would benefit from. So Ashley, I'll turn to you to run the Q&A. And thank my colleagues on the court for their participation in today's court session. Thank you very much.
Great, thanks, Denga. I mean, I may call upon some of you to answer some of these questions depending on what they are. So the first question I have is, does the reputation of the arbitrator enter into the analysis in any way? As far as the Secretariat comes, this is not something that's ever mentioned in an agenda. The circumstances are really taken on an objective basis. And we don't mention, in terms of conflicts, previous work done by the arbitrator. We really do look at the objective facts, unless the court members have other views.
I would just confirm that. I mean, I've seen situations where very big name arbitrators have been under consideration, and the fact that they are big name arbitrators is irrelevant. I mean, it's all dealt with objectively.
Right, the next question. What are the steps or criteria by the court in deciding the appointment or refusal of appointment of an arbitrator in relation to the ICC rules, the IBA rules, or other discretionary power of the court? So I think this may have come across, this was one of the earlier questions. Hopefully some of this came out during the discussion, that the court is not bound by the IBA rules. We use our own system. The court takes, like I say, an objective basis decision based on the facts. It may, though, be guided by what the IBA guidelines say or what the past precedents of the court are, but there are no specific criteria that's used. It's really done on a case-by-case basis.
And just to add to that, Ashley, that often we see that when one party objects to confirmation, or even at the stage where you're objecting to the or challenging the arbitrator, that the party itself will raise the IBA rules or will mention the IBA rules. And in that context, the court will deal with the issues raised, as they are raised, whether it's from the party objecting or from the other party. But ultimately, the court follows its own practice.
Yeah, and perhaps just also to mention there, Danga, too, that I think the person who posed the question in terms of hierarchy of rules that are applied, they set them out in the correct order: ICC rules, IBA guidelines, and then any other power, discretionary power of the court. I think it is interesting just to note, though, that some national courts, well, in fact, many national courts will refer to the IBA guidelines when the national court is faced with the question of challenge. So I know that is something that, although the ICC court is not bound by it, the IBA guidelines are taken into account, similar to how they're taken into account by national courts in deciding or looking at similar questions.
So the next question was, if the respondent is not provided with disclosure on prior mediations, I presume mediations or arbitrations, how can the respondent determine if there is a conflict on impartiality and any cross-contamination of information from case to case? The arbitrator would have a distinct advantage of inside information on the firm he or she is supposedly impartial to. So I think here this is one of the roles of the Secretariat and the court when we're looking at, I think, in the context of repeat nominations and what information the arbitrator has. Obviously, the respondent will never know what happened in the previous cases because they're confidential, and that's how it should be. But what the Secretariat does, and in assisting the court, is really try to give as much information as to what the previous cases were and what the subject matter was, and in the current case as we can for the court to make a decision. And I guess if there's ever a case where it's really not clear what the subject matter was, then that may lead the court to have more of a concern as to, in the case example that we gave, where we had all the background facts as to the previous cases and the current cases. I don't know if any of our court members have a comment on that.
Only to agree, Ashley.
Lovely. Next question. Under what circumstances will the Secretariat indicate a preferred result before referring to the court? So the Secretariat, it's not so much that it's given a preferred result before going to court, but the recommendation would be given within the agenda that is provided to the court members a few days in advance of the session. And so what the Secretariat would do, as I explained, would be to analyse the situation, set forth all the pertinent issues, and then if it is something quite simple where we've seen this many times before, we would make a recommendation, and if it's not simple, then we would leave it as an exam into other. However, the decision that comes is always that of the court. So the court is under no obligation to then follow the recommendation of the Secretariat, and quite often it does change during the discussion after the court members have different views.
And I think actually that's an important point to underscore. So while the court does benefit hugely from the guidance given by the Secretariat and the recommendation made by the Secretariat, the responsibility for the decisions remains with the court. So there are instances where indeed the court will follow the recommendation, and that's frequently so because the work of the Secretariat is very thorough and takes advantage of the court's 100-year history of deciding similar issues. But that does not mean that the court will not deviate from that recommendation where the court members feel that it should be a different decision. And that examines whether the Secretariat, from my experience, is can be quite conservative in giving an exam to the recommendation, and it's really to give the court an opportunity to fully discuss the matters where it may not be a clear-cut decision. But the briefing that the Secretariat gives in the agenda is extremely thorough and provides the court with enough background information to take a decision on these matters.
And Danga, just in addition to that, I think as a court member, when you receive the link to all the documents, I know for me, when I'm, take a first look through it, where you see the Secretariat examines whether, that really flags for me, this is something where we'll need to have a bit more thought. We're going to have more discussion because it's not clear cut. For many decisions of the Secretariat, the answer is quite obviously yes or no, or to confirm or not to confirm, or to fix whatever needs to be fixed in terms of place of arbitration or advance on costs. But where we see something like that examines whether, particularly where it comes to scrutiny of awards, that to me indicates this is something I'll probably need to spend a little bit more time on. There will be more discussion on this. And this is something where either it's a unusual issue or a novel issue, or it's an issue on which the court has discussed back and forth. And it's one of those issues where it may be very fact specific as to how the court will come out. But I agree absolutely, the work being prepared by the Secretariat is excellent, it's very thorough, and it's a very good basis to start the discussion, but it's just that, it's the basis for the discussion. The ultimate decision is very much that of the court.
And perhaps I can just say, and it plays into one of the other questions, when we prepare for these court meetings, it's a lot of work. You have to be very thorough. You don't just take what the Secretariat has prepared and give it a nod through. There's always rigorous analysis and thorough discussion.
And that takes us very nicely into the next question, which is, it seems to require quite a bit of preparation for the sessions. Absolutely it does, and we're very thankful for all our court members who take so much time out of their very busy schedules to come to the sessions, because we really do throw binders and binders of decisions at them. But the question is, how often are court members called on to participate in sessions? And I guess it depends on the person. We have a coordinator who sets out what sessions are upcoming, and then members can sign up. I mean, our poor vice presidents obviously have to participate a lot more because there are fewer of them, and we have to have a vice president or the president at each committee session and special session. But I don't know if Louise or Robert, you have an idea of how many sessions a year you participate in, and the distinction between the normal committee sessions and the special sessions, which you may attend more frequently.
Yeah, thanks, Ashley. This is, I mean, it's a really interesting question. And it's not so much a question of court members being called upon so much as we put forward dates on which we're available. And that's very much dependent on each individual's availability and calendar. I try to participate every 2 or 3 months. In terms of preparation, when I first started sitting as a court member, I used to have to set aside a day and a half, so a full day and a half for preparation for a court session. I've now got that down slightly. With experience, I've got it down to between 6 and 8 hours, but it's still the equivalent of a full day's work. So you can appreciate when, with everything else that's going on in your own practice, when you've to set aside a full day to prep plus half a day for the session itself, it's quite an undertaking. So I would say my goal, I suppose, is to attend every 2 or 3 months, and then there are additional sessions like the annual working session, which I always do my best to attend. But it's somewhat work dependent, other work dependent, but it's as regular as I can make it, which is usually every few months.
I would second everything that Louise has just said, and also mention that there are some court members who are just phenomenally conscientious and who do somehow seem to attend every session, or at least every plenary session, and I take my hat off to them, because I mean, it is a huge amount of work.
And as Ashley said, for the vice presidents, we have to attend a bit more frequently. So I do about once a month, chairing a committee session. And then sometimes I'm called upon to chair an award where the vice president who's chairing is conflicted. So it can be a bit more frequent than for every 4 weeks. And then, a sprinkling of special committee sessions, which I would chair if Claudia is not available. But I would attend at least 4 or 5 special committee sessions without chairing.
I think we just have 4 minutes left, or 3 minutes left. There's just one interesting question that I'd finish up with, and the question was, when we're looking at the number of repeat nominations, would you also look at cases where the arbitrator was nominated but not confirmed in putting the undue influence? I guess the practice here, we would look at cases where an arbitrator wasn't confirmed in specific circumstances, because there was one of the examples that we gave about whether there was a pattern of nominations, and if it does look like there's a pattern of nominations between a party and an arbitrator or counsel, the mere fact of being nominated, even if the person didn't act, may be relevant. But again, it's very much on a case-by-case basis.
And just to add to that, just about looking at the full picture, sometimes we have instances where an arbitrator will have been appointed, but the case will have settled after a few weeks or before anything happens. And these are some of the circumstances that the arbitrator or the party that's seeking confirmation might raise to say, well, it looks like it's an appointment, but this settled before anything could happen, and we look at that full picture, not to say one way or another, but that also features as a consideration that the court would take about the arbitrator.
Well, thank you everyone for joining, and sadly we're out of time. I know there were lots more questions that you had. If you do have specific questions, please feel free to get in contact with Colleen or I, and we're always happy to have discussions as to court practices and how the rules are applied, so do get in contact. Thank you so much for all our speakers today. to Dango and Louisa and Robert for taking even more time out of their busy schedules to help us do a mock session, as well as all the actual sessions that they so diligently prepare for and attend. So thank you for our speakers, thank you for our participants, and we hope that you enjoyed the rest of the day. I know you've got quite a full schedule, and I'm sure it's going to be very interesting and informative for you. Right, thank you.
Thank you very much all. And thank you to the participants for being so active in the questions. That's always a good sign when people are asking relevant questions. So thank you all.
Absolutely. Thank you very much.
Thank you. Goodbye.
Bye-bye.
Thank you.